and welcome back to another episode of I'll Allow It Nevada, your go-to podcast for insightful glimpses into the Nevada judiciary. I'm your host, Seth Easley, representing the Supreme Court of Nevada Administrative Office of the Courts. In our last episode, we began an insightful conversation on the fundamental topic of evidence. So let's jump right back in with our guest, Senior Judge Richard Glasson, to continue our exploration of this important topic. So the law recognizes both direct and circumstantial evidence. At a high level, how do you distinguish between the two?
I don't.
Okay.
Because circumstantial evidence only exists because there's a basis in specific evidence, in physical evidence, in testimonial evidence. For example, if there was only specific evidence, a witness would say, I saw nobody in the cabin. The cabin must have been empty. Mm-hmm. Circumstantial evidence would be, well, did you see anything else? Yes. What did you see? I saw about 6 inches of snow on the roof and 6 inches of snow on the ground. Mm-hmm. Did you see any disturbance of the snow on the ground? Yes, I saw a set of footprints going to the cabin, up to the cabin door, and I saw no footprints coming back. Okay. So now you have the first evidence, the physical and direct evidence saying, I didn't see anybody there, mm-hmm. But then you have very strong circumstantial evidence that unless the person could levitate, a human being entered the cabin.
Right.
And so circumstantial evidence and direct evidence are both valid forms of evidence, and no one is stronger than the other. Attorneys love to argue to a jury, the evidence is only circumstantial. Mm-hmm. Well, sure.
You hear that a lot on TV and stuff.
Yeah. And that's, if you don't have anything else, that's what you use. And you pound on the table and you say, it's just circumstantial. But isn't that what Bart Simpson always says? Bart Simpson says, I didn't do it. Mm-hmm. Nobody saw me do it. You can't prove a thing. Certainly you can prove things without an admission, without a confession. And most evidence is circumstantial. And, and that's where you get the fun of it. And I want to just circle back to something when you're talking about how does a judge separate what is valid evidence, what is relevant evidence, and what is irrelevant or invalid. Mm-hmm. There are a couple of other things that a judge would never consider, which would be settlement negotiations. Okay. You can certainly object if somebody tries to say what you talked about during settlement. But even if it came out, the judge wouldn't consider that. Mm-hmm. Because we want to encourage settlements. And if we start putting weight on the scales of justice based upon somebody's willingness or unwillingness to settle a case, we're not doing our job. Mm-hmm. Same thing with a subsequent remedial measure. For example, I had a client, a hotel casino, that had very dangerous beds. Mm-hmm. And people were falling out of their beds and hurting themselves. And even our insurance company said, you got to get rid of these beds. And if you do anything, please don't put old people in the rooms that you haven't retrofitted. And we put old people in the rooms that we hadn't retrofitted, and then they broke their hips. Evidence that we were fixing the rooms is not admissible.
Okay.
But evidence that we were told not to put old people in those rooms and we did otherwise, that's admissible. Mm-hmm. And so because we want to encourage people to do the right thing. And so if we punish them for putting in evidence that they were doing the right thing after the accident, that had no bearing on the original accident, and that can't be used to prove that they were negligent in the first place. Mm-hmm. And then irrelevant or highly prejudicial evidence or cumulative evidence is irrelevant. Mm-hmm. So we want to make sure that we stay away from those things. I want to make sure I mentioned that before we moved on. And certainly, and then demonstrative aids without proper foundation are irrelevant. But demonstrable aids, they can really win your case.
It sounds like we could do a whole episode just on what's not admissible, like what's not valid.
Or you could probably do a whole episode on, at least for attorneys, on demonstrative evidence and how compelling it can be. Mm-hmm. Sometimes the sound is more important than the substance.
Interesting.
Yeah, that's a whole nother war story. But a judge does give equal weight to all evidence, and it's just the cumulative evidence that will help you. And it might be one thing that just overshadows everything. Or sometimes it can just be the drip, drip, drip.
So I had a couple more questions prepared for the direct versus circumstantial evidence, but you made it pretty clear.
Okay.
So why give equal weight to both?
It's not equal weight, but equal consideration.
I see.
Because the more evidence, the better. The more compelling evidence, the better. But evidence doesn't equal proof. It's the sum. You can have a great case, but be lacking one of the elements, and it fails. You have to establish each and every element of the crime, each and every element of the contract, each and every element of the tort. And if you don't, you haven't proven your case. On the conversely, each and every element perhaps of an affirmative defense.
On that note of the evidence not necessarily equaling proof, so how should judges think about the relationship between evidence and fact-finding?
Evidence is the sum of the facts. So the fact-finding is, it's true that the numeral 2 is not the numeral 10. But it is also true that 5, I don't want to get a homophone there, that 2 3s and a 4 are a 10. And so if you can establish cumulatively the proof that you need, you've established the case. Proof and evidence is proof. The sum of the evidence is the proof that you need. And it's important for judges to remember that weighing the evidence belongs to the fact finder. Sometimes that's the jury, sometimes that's the judge.
And so why is it important for judges to remember that?
Well, judges want to be correct. It's important for judges to keep an open mind, and like my case with the presumption, don't close the book until it's all in. And sometimes it's in there, but you need to find the rule of evidence to pull it out. You don't know it until you look for it. I find that in civil cases, I don't make my decision until I'm writing my judgment. I find that the exercise in putting my thoughts down on paper, Seth, I'd say a good third of the time, I come to a completely different conclusion once I start trying to analyze it all and put it down onto paper. I'll find something and overlook that I might have overlooked. And you put together your summation, and then of course what you do is you say, this is my preliminary decision. I'm ordering the plaintiff or I'm ordering the defendant's counsel to prepare findings of fact, conclusions of law, and a judgment for the court. And then you edit from there, because the judges don't care if they're appealed, but basically you want to be upheld. And so you put the burden on preparing that judgment on the party that's going to be defending you on appeal. And then you forget about it, because if your case is appealed and the case is reversed, it just proves that the appellate court didn't know anything. Having the last word doesn't mean it's the correct word.
That's yeah.
But it is the word that we're going to follow from here on out.
Right. So you've mentioned this idea a couple of times of evidence just being pieces of a bigger story. So this question feels rather simple, but so how does individual evidence fit into the bigger picture of how a case is proven?
Okay. Well, some people talk about it thinking of evidence as pieces of a puzzle rather than isolated facts. Most attorneys and all judges are binary problem solvers, binary troubleshooters. You start with a proposition, your base proposition and you move to the next depending on what happens. One of the most important, well, nobody's going to read it now, but there are two books that help folks become binary troubleshooters. One of them is called Zen and the Art of Motorcycle Maintenance. Everything's either a left or a right. Everything's either viral or bacterial. How are we, is it flesh or feather? And the other book is by a fellow named John Muir, not the naturalist, but he was a mechanic and a wonderful writer. It's called How to Keep Your Volkswagen Alive. The judges can follow the same thing. Your Volkswagen doesn't start. Okay. Do you turn the key and you hear nothing? Okay, if you hear nothing, it's probably not you're out of gas. It's an ignition problem, or a fuel pump delivery problem. You're eliminating things one at a time, right. And that's what judges do. Is when you go to the emergency room, staff is doing a binary analysis. Are you walking when you come in? Mm-hmm. If you're walking when you come in, they usually eliminate a spinal injury. Mm-hmm. They're looking for something else. Are you bleeding? No, you're not. That's what judges are doing when they look at evidence. Okay. Is this relevant? And if it's relevant, where does it fit?
Okay, I see. Yeah, that was my next question. So, is there a way we can expand on how thinking of evidence as a piece of a puzzle is helpful for judges?
Well, I don't like to think of it as pieces of a puzzle.
Okay.
I like to think of it as either elements of a compound, if you're looking at scientifically, mm-hmm. or mathematically, where does it fit in the equation?
Okay.
I remember diagramming negligence once, and it was a huge diagram.
Okay.
Like you diagram a sentence. You'd start with the action, and you'd go from there. It's the same way with anything you consider as a judge. What are we looking for in the final analysis? Is a contract case. Mm-hmm. Okay, has there been a breach of the contract? And if so, what are the damages? So you start with, is there a contract? Mm-hmm. And then what are the elements of that contract? Then within it, what has been performed, what has not been performed? And then when you get to the final analysis, what does it cost to remedy the failure to complete the contract? And of course, the first one is there a contract?
Right.
You don't get that analysis of the breach of the contract until you find that there is a contract. Mm-hmm. So it's not a puzzle, it's an equation.
Okay. It's interesting. That's an interesting way to frame it. So what's missing from the equation? Or where does it fit into the equation rather?
Right. Yeah. Does it add up?
There you go. Hi, everyone. I hope you're enjoying this episode of I'll Allow It Nevada. We're always striving to bring you valuable insights and education, not just for judicial officers, but for anyone interested in the Nevada judiciary. If you find our content helpful or intriguing, please share your experience with your friends, family, and colleagues. Your support helps us reach a broader audience and ensures that more people can benefit from our discussions. Thank you for listening and supporting I'll Allow It Nevada. So let's move on to some takeaways, I guess.
Okay.
So for a judge, say it's their first day on the bench, hypothetically, what's the most important thing for them to remember about evidence?
Slow down.
Okay.
Slow your roll. Don't worry. Be happy. Mm-hmm. You're really just sitting as a one-person juror. You just weighing the evidence. New judges should worry not about evidence, but about objections.
Okay.
Cases are seldom overturned because a judge rules one way or the other on a particular objection. Mm-hmm. In Nevada, trial court evidence is rarely overturned on appeal because appellate courts focus on legal errors rather than reevaluating facts or witness credibility, because the judge has already weighed the witness's credibility, has already considered the facts. Decisions regarding evidence are reviewed under an abuse of discretion standard. Is the ruling The ruling will be upheld unless it's arbitrary, capricious, or cause significant legal presidential error. It's like a baseball umpire.
Okay.
You know, I guess we're getting robot umpires now, mainly because of internet gaming. They don't want a game decided because of a ball or a strike, because that's going to cost somebody some money.
I guess that makes sense.
Yeah, it makes sense, but it's I don't know. I'm a purist.
I agree.
But let's say 5% of the time, an umpire calls a ball when it should have been called a strike. You know, maybe it's on the border, or maybe it's way off. Does that affect the outcome of the game? You know, if you've got an umpire that's 5% off, it's your duty as the manager to tell your players, swing at those low outside balls. And it's the same thing as a judge. Missing 5% of the objections, or letting in 5% evidence that you shouldn't, or excluding 5% of the evidence that shouldn't come in. Don't waste time on that. When I meet with, we call it baby judge class. It's judges that have just been elected in November, and they're going to work in January. We have, through the AOC, we have some programs we teach. When I teach baby judges, I love to use audio-visual aids. And I'll just start pulling stuff out of my briefcase and put it out there, and I say, what is the most important thing out here? And I've got a laptop, I've got a statute, I've got a copy of the Nevada reports, you know, I've got a telephone, I've got a pencil, and I say, the most important thing is this, and I pick up the telephone. I said, if you get stuck, if something is bothering you, and you're even in the middle of trial, you just say, oh, I'm sorry, I've got to take care of some judge business. We're going to take a recess for a minute. Go into chambers and call another judge. Judges universally in Nevada, when they get a message on the bench that another judge is calling, they'll say, excuse me, I've got to take care of some judge business. And they will go into chambers and they'll take your call. And you discuss your problem with them, and they say, you know what? Let's call up Tom Perkins. Tom knows that. And Tom will stop his hike. He'll put his dog on the leash and he will take your call and he'll walk you through it. We have the most amazing network of knowledgeable, helpful judges here in Nevada. That's what you do when you say that first day is slow down. Take it all in. Don't worry, be happy. And if you get stuck, we're all here to help you.
Feel free to lean on that network of expertise.
We're all part of that network. You know, there's some, I have some favorite judges that'll call a lot. I have some judges that I will call a lot. And it's fun. And if you have to call Gino Draculich, you're going to get a joke as well.
Yeah, that's a bonus joke to go with some advice. I love that. So, starting to round out the episode. So how does having a clear and grounded definition of evidence make later rulings easier and more confident?
That's what you build on.
Okay.
I mean, we've been building on evidence since second year law school. I had, and evidence professors are typically nerds, of course. Evidence professors are largely former trial lawyers and judges. My evidence professor was a chief justice that had retired and was teaching evidence, because you don't get anywhere without it. It's the most vital course at law school if you want to be a judge or if you want to be a trial lawyer. You need to know it upside, downside. You need to know evidence. And Nevada judges are like this. If you've ever watched any of the old Bruce Lee movies, or nowadays, whenever they've got, you know, the Jason Statham or those guys that never, you know, the bad guy always has this guerrilla army.
Right.
All the bad guys have this guerrilla army. And when he has to go down the hallway, he's, whether in slow motion or not, he's hitting the guy behind him who's coming at him with a bazooka without turning around.
Right.
Bruce Lee did the same thing. That's what trial attorneys are. They know evidence so well that they have their case ready to go. So if there's an objection, they have it nailed down why their evidence gets in. They also know what the other attorney is going to try to pull and have their objections ready, so that it's just like hitting that guy from behind you. And so by the time you're actually, after all these years of experience or after the training you get through the AOC, you're like that. You know what the evidence problem is going to be before the other attorney objects. And sometimes you object on your own if you don't have a jury there. Judge has to be real careful when there's a jury of stepping on the attorney's toes. But a judge can always, with regard to relevance, say, can you explain to me how this line of questioning is relevant for the jury? Because that'll help not only frame it, but sometimes shut the lawyer up.
Right.
I recall in a jury trial, a civil case I had with Judge Gamble in Douglas County, and the attorney entered into an irrelevant area. And just like the title of this program, I said, Judge, I object. It's relevant. It's not relevant, and any relevance it doesn't have any weight. And the judge says, I'll allow it. And so I sulk, and I let the attorney do it. And he gets into this area, and it's way irrelevant. And he's going way down in the swamp. And it goes on for 10 minutes, 11 minutes, 12 minutes. And I'm just doodling, looking down at my pad, and I catch a look at the judge. And the judge is giving me the eyebrow, like, object. And it's like, I'm not going to object. I objected before, and you dissed me, and so I'm going to make you suffer. And so finally the judge said, counsel, move on. Go to a new area. And, so attorneys can be petty too.
Yeah.
But a judge will sometimes look to an attorney and with a little bit of a nod or some sort of a head, like, or shake its head to give a hint if there's a jury. Because you don't want to be cutting counsel off. You want counsel to do their job for them.
Right. And I have one last question before we wrap up this episode finally. It's similar to what I asked before, but so our listeners, we do have a lot of judicial officers listening, attorneys, court staff, but also members of the public. So if listeners walk away with one clear understanding or an additional takeaway, I guess, what should it be?
Trust the Nevada judiciary. You're going to get a fair hearing from an unbiased judge who is always going to be courteous, dignified, and patient. Judiciary is here to make certain that the game's not rigged, that you're going to get an even roll and a fair deal. We go out of our way to educate ourselves. My association, the association, what do we call ourselves now? The Nevada Judges of Limited Jurisdiction. We educate ourselves. Twice a year, we'll get away for a good 15, 16 hours of continuing education on subjects like evidence and everything else under the sun. If you go away with anything, if you're listening to this, Nevada judges know what they're doing. There's 3 branches of government, and one of these branches is beautiful and has blossoms in the spring and fruit in the fall, and that's our branch.
I love that. Well, Judge Glasson, thank you very much for joining me. I personally learned a lot, and I know my audience will take a lot away from this. Any last messages for the audience before we close it out?
I hope you found that this podcast and my closing remarks were fruitful.
Thank you, Judge.
You're welcome.
A heartfelt appreciation to our guest and to everyone who has tuned into this podcast. Before we wrap up, here are a couple of quick important reminders. For continuing legal education credit, be sure to complete a certificate of attendance and email it to jepodcast@nvcourts.nv.gov. If you have any questions, topic suggestions, or comments, we welcome your input. You can email us at jepodcast@nvcourts.nv.gov or submit your topic ideas to the topic suggestion form linked in the episode description. We value and look forward to hearing from our listeners. Stay tuned for more episodes of I'll Allow It Nevada. This is Seth Easley signing off. Take care, Nevada.